Hello. Today we're going to talk about how you want to provide for your loved ones after your death. I'm Mona O'Connor, and I am a partner at O'Connor Law Offices in Orland Park, Illinois. My areas of practice are solely in estate planning and trust administration. Prior to joining O'Connor Law Offices, I was a director at Deutsche Bank in the private wealth management group. I was also a manager at a Big Four accounting firm in both the audit and the tax areas. And then prior to that, I was also a vice president in wealth management at LaSalle Bank. The rest of my credentials are listed here on the screen, but most importantly, I am a member of Wealth Council and I run the Illinois Forum for that group. So, when you sit down to create your estate plan or to update it, I understand this can be a very overwhelming process. But what is crucial to a successful plan is your ability to address really two main issues. Number one, who will receive your assets, your accounts, your uh, personal items after you pass away? And number two, how do you want those people to receive those assets? So today we're actually going to look at the second question in detail and figure out how we can help you address that. So as an overview, there are some options that you have available to you when you are looking to craft your estate plan. And there are several ways that you can leave money or property to the people or entities that you wish. One of those ways could be outright. The other is via a trust. And then, as you see here on this slide, once you make the decision to leave it in trust for them, then there's a whole host of other questions that come about. Do you want them to get a sum of money over a period of time or a percentage over a period of time? Do you want them to get a sum of money or a percentage when they reach a certain milestone age? Do you want it to all be at the trustee's discretion? So there is a lot to consider here, and we're going to talk briefly about each one of those. So, outright, one way that you can give your money and your property to your loved ones is outright after your death. This means that once you pass away and the administration process for your estate has been completed, your beneficiary will receive the account or the property, etc., right? With no strings attached. It immediately becomes theirs to do with whatever they want, and it gives the beneficiary the maximum freedom. They can keep the account or property, they could spend it all, they could liquidate it, they could give it away. Another benefit with this option is that it is the easiest distribution plan for you. You basically state in your will or in your trust that the beneficiary will receive the account or the property outright. So when it comes time to distribute the money or the property at the end of the administration process, the account or property will be turned over directly to the beneficiary. But this freedom comes with a cost. Okay. If the beneficiary has creditor issues, if they're going through a divorce, if this person is not good at managing money, that inheritance could be gone very quickly. Now, one thing I want to address while I'm still on this page is I had mentioned several times that at the end of the administration, what does that mean? So after you pass away, there's a period of time where we have to pay all of your final debts, your final expenses. We have to pay your income taxes. So once those items are wrapped up, that's when we're talking about actually distributing the assets to the beneficiary. So outside of leaving it to them outright, what are the options? Well, again, you could leave the money in trust for them. That means that you would basically be signing a revocable living trust, and that trust document contains a provision whereby the beneficiary's share is left inside the trust for their benefit. So being held in the trust means that the beneficiary will not receive everything at once. One set of provisions could give a beneficiary a sum of money or a percentage at a certain age. For example, 1/3 of the trust gets distributed outright to the beneficiary at the age of 30. 1/2 of the remaining trust balance gets distributed out to the beneficiary at the age of 35, and then the remainder at 40. So there's a 3-tier structure to the distribution. This basically means that your beneficiary will slowly have access to the inheritance. And so if they make a bad choice at the very beginning with the first distribution, they still have time to learn from their experiences before being given additional sums of money. Another option when the inheritance is held in a trust is to have the amounts or percentages distributed to the beneficiary when they reach certain milestones in their life. An example of that would be 1/3 of the trust upon earning like a post-secondary degree, meaning graduating from college, or obtaining a trade school certificate, or maybe even an honorable discharge from the military. The 1/2 of the remaining trust would be distributed to them upon successfully acquiring or maintaining employment with the same employer for 5 consecutive years. And then the remaining amount maybe upon a later age or even at retirement. Now, one of the things that I want you to understand is things do change. Society changes over time. So if you say that they get the second distribution for staying with the job for 5 years, one of the things that you have to consider is now employers may not be providing the same benefits as when you started working. So they may not have life insurance. They may not have the ability to save for their retirement through their employer. So by saying that they have to stay with an employer for 5 years, um, it's kind of a trade-off. And so think very carefully about that. In addition, I want you to think very carefully about saying that the rest of the money has to be held until retirement. If the beneficiary is someone that is younger than, I would say, 55, that money will be held in trust for a really long time. So the option to have them receive money at certain milestones allows you to include what those milestones need to be and what you expect of that beneficiary or what you want them to achieve. If the beneficiary does not achieve the first milestone, they still have an opportunity to access the money by completing one of the other milestones. A third option when setting up an inheritance to be set aside in a trust is to describe specific instances in which the trust's money or property can be used. Okay. An example of that would be an amount equal to the average cost of a wedding in your area or the average cost of a home in your area. Now, I want you to also be careful in this regard because housing prices, at least in my area here in Orland Park, have really increased over the years from the late 90s to now. So, if you set a specific amount aside, recognize that that amount may not be applicable at any point in the future. Another option is that they get 50% of a startup capital need to form a business or to buy into a franchise or anything like that. I always recommend, though, that if that's one of the options that you want to create, is that you require that the business plan be submitted to the trustee for approval prior to the money having to be distributed. But these types of provisions will allow you to tailor the inheritance of the funds for the events or the experiences that you think are important and that you would have wanted to be a part of had you not passed away. Now, some beneficiaries may benefit from a more restrictive set of terms for their inheritance. And this is where a discretionary trust comes into play. It is still a revocable living trust document, but the document contains discretionary provisions instead. These types of provisions mean that your beneficiary will only receive money from their trust if the trustee thinks it is in the beneficiary's best interest. While this may seem really restrictive, especially to the beneficiary, this allows the trustee to evaluate the beneficiary's situation at the time that the beneficiary is requesting the money, and they can adapt to some changing needs. By removing the amount, by removing the right to the inheritance, any money or property that is in the trust that's not been distributed to the beneficiary will likely be unreachable by that beneficiary's creditors. What would a creditor be? Potentially a divorcing spouse, or their credit card company, or if they were sued, um, someone that received a judgment against them. With discretionary trust provisions, you need to understand that once the money is given to the beneficiary, that's when the creditor can attach to it. So this allows the trustee to protect the money and the property to the greatest extent possible. Now, beneficiaries that have a disability, if they receive assets outright, this could make them ineligible for means-based governmental benefits. Okay, so we really need to structure their inheritance appropriately so that we're not jeopardizing this individual's ability to receive benefits or the ability to receive benefits at some point in the future. This can be accomplished by including special provisions in a living trust, but what is actually even better is to create a separate trust document simply for that individual, and it's called a supplemental needs trust. The name comes from the fact that the assets that are inherited are only to be used to supplement what the government provides to that individual. It's important to note that when you create a trust document, there is a cost. There's also a cost to administering that trust after you have passed away. There are taxes that have to be paid on an annual basis for as long as the trust is in existence. And in most cases, whoever is chosen as the trustee is entitled to compensation for their time for managing it, because some of these trusts can exist for 30, 40, 50 years. It really depends upon the age and the circumstances of the particular beneficiary. When using a trust, it means that somebody or some entity must manage that trust on an ongoing basis. And that again includes filing those income tax returns and doing other administrative tasks like approving a distribution request. Again, these tasks take time, and depending upon the terms of the trust can go on for years. So you want to make sure that the person that is serving as the trustee has the ability to be compensated. Now, a lot of times I recommend to my clients, if a trust will go on for an extended period of time, that they consider naming a financial institution to serve as a trustee, because people get sick, people pass away, people have their own issues, and then they're not able to deal with this. And when you hire a corporate trustee, they are very well able to have someone else pick up the management of that trust for you. One thing that you must remember is that if you have specific wishes about how you want your assets to be distributed and how you want your loved ones to receive those assets, you must proactively take steps to document that. Just because you say it verbally doesn't mean that it will ever happen. Just because you handwrite it does not mean that it will happen. The state of Illinois has some very strict guidelines that must be met in order for a trust document or a will to be considered valid. And without putting this plan in place and actually having it documented, your loved ones will be stuck following the Illinois state statute that dictates how assets are to be distributed and in what percentages. So if you are married and you have an asset just in your name, let's say you own your house, okay? You own your house solely in your name, but you're married and you have kids. If you pass away, your spouse owns a percentage of that house, and your children will now own a percentage of that house. That may not be what you really want. So it is very important that you get solid legal advice from an attorney that is licensed in the state of Illinois if you are an Illinois resident. Do not rely upon a Google search. Do not rely upon your neighbor telling you things about their trust, because people frequently misinterpret what was communicated to them. It's also important to note that most state laws will give an inheritance to an adult beneficiary outright, and that may be contrary to what you want as well. So if you want more restrictions for your loved one's inheritance, you really need to write out an estate plan with an estate planning attorney. So depending upon who your beneficiary is, some options may be a better fit than other options, okay? So it's important that you understand basically 3 questions and that you are honest with yourself regarding the answers to these 3 questions. So first of all, who is your beneficiary? Are they a minor? Are they an adult who's not good with money? You really need to analyze each of your beneficiaries individually. What are the needs of that beneficiary? If one beneficiary went to Harvard and one beneficiary has been diagnosed with a learning disability, there's a big discrepancy then probably in the amount of money or the potential for money that those individuals could earn. You may want to consider an unequal distribution in that situation. And what's your desired outcome? What do you want for that beneficiary when they receive your assets? If you want to leave your money or your other assets to a charity, you can choose to give that to them outright, especially if there's a particular goal or a purpose that you have in giving that gift. You may also consider leaving the gift outright if you want to use that the charity can utilize the money for general charitable purposes. And I'm telling you, in most cases, that's exactly what the charity prefers when you designate such a gift, because then they're not restricted on, utilizing it for the maintenance of a building that they may end up selling, right? However, you get to choose to incorporate a charitable trust into your estate plan if that's what you would prefer to do. And this might be desirable if you have some really specific tax objectives that you want to accomplish with that. When it comes to minor beneficiaries, it's usually advisable that their inheritance be left in a trust for their benefit. Okay. This is because in most cases, especially here in Illinois, a minor cannot legally own or manage accounts or property until they reach the age of 18. So if you leave money or property outright to a minor, that means that another adult will have to go into court and get a guardianship. That's what it's called here in Illinois, over that minor until they reach the age of a majority, which is 18 here. Now, you may also not want the child to get the money at the age of 18, but under the laws of Illinois, they're an adult, so they're entitled to it, right? And that's when the guardianship ends. So, at that situation, the money would go outright to the child, who can spend it at any point or any way they want to. So that comes with a lot of risk. With a trust, you have the ability to determine who's going to manage that money instead of having a judge appoint a guardian to manage the money for the minor's benefit. And here in Illinois, if a guardianship is obtained, the guardian must go into court every year. So there's going to be additional court time, additional fees, etc. And that's just not a very good way to go. Now, when you have an adult child that's a beneficiary or an adult loved one that you want to leave money to, it really depends upon their situation and the amount you want to provide as the inheritance. All of the options could be available to the beneficiary. But when you're looking at the available options, there's a few things that you should really consider here. First, are they likely to spend it as soon as they get it? Are they likely to get a divorce? Are they engaged in a high risk profession? Medicine, law? Are they a police officer? Um, those are all high risk. Is the person receiving, or are they likely to receive, governmental benefits? So, if you've answered yes to any of these questions, you may want to leave your loved one's inheritance to them in a trust instead of giving it to them outright. A trust will utilize some specific terms tailored to that beneficiary's very unique circumstances, to make sure that the loved one benefits from their inheritance to the greatest extent possible, instead of the inheritance causing a problem for them. In many cases, a married couple wants everything that they have to go outright to the surviving spouse, right? Because you consider everything that you own to belong to both of you, okay? And you want things to go as smoothly as possible. You want the survivor to be properly provided for after you pass away. In addition to the considerations we've already discussed for other adult beneficiaries, you might want to consider the likelihood that your surviving spouse may remarry, or they may enter into a cohabitation agreement, or a relationship, or a close relationship with someone else. And if you leave all of your money to your surviving spouse outright, that allows the surviving spouse to use the money or the property in any way they want. Now, typically, I don't see the surviving spouse going, "Oh, I don't want to leave money to my kids. I want to give it all to my new honey bunny." No, that's not what I see. Typically, they just don't connect the dots and understand that, by giving these gifts to my significant other, that decreases what my children will get, right? If you don't want this to happen to your money or your assets, it's important that you have a plan in place that puts more restrictions on uh, money that you might leave to your surviving spouse. Okay. Now, if you want to contact my office to get going on your estate plan or to update your estate plan, please contact us at 708 460 8888. My assistant, Melanie, will be happy to get you going with the estate planning process, and she can either schedule an in person meeting with me or she can schedule a Zoom. As always, I have a lot of information out on my website, and you see it listed. I'm sorry, my website address is not on there. It is www.doconnor.com. So www.DOCONNORLAWFFICES.com. I look forward to helping you make decisions on how you are going to distribute your assets after you pass away. And feel free to give us a call if you have questions. Thank you.